My name is Yogya Bhatia and I'm a legal intern at Lexis and Company. Today I'll be talking about limits of sovereign immunity. The concept of sovereign immunity is developed in the common law jurisprudence. As we acknowledge and read the history books, firstly, we get to know how several countries along with ours witnessed the rule of great kings and emperors who ruled on their own decisions and the opinion of their ministers on any social and societal aspects. Thus, there were no functions of a government running by the help of people elected from within the society. As the king had various powers, while regarding his role, he was protected from punishments because the king had to run the state efficiently and effectively. Therefore, the doctrine of sovereign immunity has come into force by stating its meaning as sovereign is immune from being sued for civil suits and criminal prosecution cases because it is considered that state cannot commit a legal wrong. Thus, the legal doctrine of sovereign immunity provides a ruling to the government body with an option of choosing immunity from civil lawsuits and criminal prosecutions. India has adopted a restricted sovereign immunity that is under the Code of Civil Procedure in India. Meaning of the term. The term sovereign immunity was derived from a British common law doctrine which is based on the idea that king can't do any wrong. In the United States, sovereign immunity only applies to the federal and the state government and not the municipalities, as the federal and state government can relinquish their sovereign immunity. After the passing of the Federal Tort Claims Act by the federal government that waived the various types of tort claims, sovereign immunity deals with the fact the state cannot be sued without its consent. Concept of sovereignty. Sovereignty in political theory means the ultimate supervisor or authority which works in the decision making process of the state and also in maintaining order. This concept is of those controversial ideas from political science and international law. It relates to the difficult concepts of the state, government, democracy. This term is derived from the Latin term souverainus through the French souveraineté, which primarily means coordinative to a supreme power. Federal sovereign immunity. While discussing sovereign immunity at a federal level, an individual can't sue the federal government as an entity unless it says otherwise. Suits can be filed against federal employees under the Federal Tort Claims Act for violating rights while they are performing their roles only in case of negligence of a factor. If such an act is done, the individual should determine whether they can sue under the FTCA. State sovereign immunity. Under this doctrine, a state cannot be sued in federal or state court without its consent, as the 11th Amendment limits to only two particular situations in the federal court. The Supreme Court doesn't hold the immunity derived by the said amendment. A state court can invoke its immunity even when it is issued under an otherwise valid federal law. The state has the full authority to explain the scope of its immunity from the suits based on its state law. Types of sovereignty. Normal and real. In the ancient period, many states had the rule of a kingdom that was ruled by the respective kings. They wielded absolute power, but the senators were a bit powerless. Therefore, it resulted in the exercise of real sovereignty. Legal sovereignty. It is that authority of the state which has the power to give and issue final orders or commands. In all states ruled by kings, certain laws should be read and obeyed by its people, and it is also necessary to have the enforcing and issuing authority for these laws, which needs own a legal sovereignty. The authority of the legal sovereign has to be absolute, hence the law is the will of the sovereign. Hence the legal sovereign is always definitive and determinate. Political sovereignty. Dicey says that behind the sovereign which the lawyer recognizes, there is another sovereign to which the legal sovereign has to bow. Sovereign is known as a political sovereign. In all states which are governed by rule and order, the legal sovereign has to pay proper attention to the political sovereign. This is one of the vague and the indeterminate terms. The sovereign immunity legal maxim. The legal maxim of sovereign immunity recognizes the principle of rex non potest peccare, which means the king can't do any wrong. It is based on the common law principle of British jurisprudence, which says that a king cannot be held liable for the act of negligence or misconduct and also cannot be held for the act of his servants. The other attribute of sovereignty is that the state cannot be held liable for any legal wrong in its court without its consent. The Indian courts have declined it and it is not in use since the mid 19th century till the present. The Indian court has always given first place to the genuine claims by keeping the scope of sovereign functions narrower, so that those genuine claims could get damages. The Lord Commission of India in its most first report has recommended the abolition of this outdated doctrine. But due to various circumstances, the bill for this recommendation of the abolition of this doctrine was never passed. It was left on the courts to decide on the comparability of the said doctrine according to the Constitution of India. Thank you.